Thank you, Madam President. I rise to explain my vote.
Please do.
Madam President, as just mentioned and was mentioned earlier, there was a concern about birth or place of birth being placed on the registration form. That's already done. That's already the case. So that's not a change here. Madam President, what's the issue here? What is the issue? The issue is making sure that citizens of this country are voting. And if you're not a citizen of this country, you're not allowed to vote. That is the issue at hand. We're getting distracted, but that is the issue. And I hope we all agree that only citizens should vote in our elections. Now, right now, in this state, in the state of Arizona, we have over 35,000 people registered to vote whom we are not certain whether they are citizens or not. And it is clear that the legislature has plenary authority in this area of our registration forms, of how they should be done and how they should be written. I want to share a letter here in support of this bill that has been sent by a coalition of 11 organizations who are involved in election integrity, and that is what they are seeking. And it provides a nice outline, a nice history on the concern here and what's going on. In 2004, the Arizona voters overwhelmingly approved Proposition 200, which in part required that the county recorder shall reject any application for registration that is not accompanied by satisfactory evidence of United States citizenship. That's now codified as 16166. Unfortunately, over the last 2 decades, this voter-approved requirement has been whittled away. Why? In 2014, the U.S. Supreme Court, well, first, before I get to that, some more history on this. In 2014, the U.S. Supreme Court and Intertribal Council decided that the National Voter Registration Act, NVRA, preempts us from requiring information beyond that which is requested on the federal form created by the Election Assistance Commission. As a result, Arizona has bifurcated our voter registration system to register all who applied on the federal form without documentary proof of citizen, DPOC, as federal-only voters. So then in 2018, Secretary of State Michelle Reagan and Maricopa County Recorder Adrian Fontes entered a consent decree with the League of United Latin American Citizens agreeing that Arizona could accept state voter registration forms without documentary proof of citizenship. That essentially had nullified, at that point, we essentially nullified proof of citizenship requirements. This is something we're able to do. May have been implemented and nullified, but we can implement it and make sure that we're doing it. So the result has been this proliferation that we've seen of the federal-only voter list. It was very small. Just a few years ago, it was 1,700. And as I've mentioned now, it's proliferated over 30,000. So this is a critical insecurity in Arizona's elections with the potential to impact outcomes and seriously undermine the electorate's confidence. Additionally, as Congress contemplates legislation that would constitute a federal takeover of elections, it's more important now for states to assert our constitutional authority over elections. So first of all, HB 2492 takes us back to our practice of the LULAC consent decree enforcing proof of citizen requirements on our own state form and rejecting state applications submitted without the proof of citizenship. Intertribal Council affirmed that we have this authority when Justice Scalia wrote that, quote, states retain the flexibility to design and use their own registration forms. Additionally, that the consent decree does not preempt any of these provisions. Second, HB 2492 requires counties to check databases to obtain evidence of an applicant's citizenship status who submitted a federal form without proof of citizenship. This process and the databases outlined in the bill is exactly the same process that's been recommended by the EAC for federal forms. So the bottom line is, all we're doing is what we are authorized and have plenary authority to do. We're making sure that if you are, we're doing everything we can. This still even leaves, there's still a relief valve on this. If you can't prove citizenship, you, at the end of the day, after these processes have been followed, then you can still get a federal-only form. This is just help making us do more checks and more balances to make sure that if we are certain that somebody's not a citizen, that they're not voting. The third thing that this bill does is makes proof of citizenship a qualification to vote in presidential elections. And while Intertribal Council relied heavily on times, places, and manner clause of the U.S. Constitution, which does grant Congress power relating to times, places, and manners of representatives and senators, it does not enumerate that power to Congress. Only the legislatures retain and hold that power. The last thing that 2492 does is it makes sure it makes a qualification to vote in early mail. And the courts have repeatedly affirmed that there's no constitutional right to this. As recently as 2020, there was a Seventh Circuit decision that says, quote, as long as the state allows voting in person, there's no constitutional right to vote by mail. That's Tolley versus Okeson. So, Madam President, again, this is just a critical bill and a critical and important role we have as a state, simply to make sure that we as U.S. citizens are voting. And if you're not a U.S. citizen, that you're not allowed to vote in our elections. With that, Madam President, I vote aye.
Thank you, sir.